Good afternoon, gentlemen. You're on mute. All right, who's ready in the jail?
The Schmidts are ready.
The Schmidt and Schmidt show.
Yes, sir.
I thought that was a morning show. I didn't realize that was an afternoon show.
Could be either.
You want Miss Bacosby?
I actually don't represent her, Your Honor. Mr. Manning represents her. I represent her on the original case.
Well, your name keeps getting pulled on my docket.
Okay.
Miss Abraham didn't take it off, so I'm going to have to give her demerit for that. So.
I have Gustavo Castillo, Your Honor.
All right, Mr. Castillo, come on up. Cause number CR 22-319. State versus Gustavo Miguel Castillo. Motion to revoke. Go ahead, Mr. Schmidt.
Your Honor, I was just hired on this case within the last week, I believe. I have spoken with the prosecutor for the state about the allegations, and they're going to get with probation and tender me an offer. If we could have a 30-day set off, we hope to have an agreed resolution. And I will be here on your jail docket on the 26th, if that's available.
26th. That's our next contested docket. So, all right, court will set Mr. Castillo for hearing on his motion to adjudicate on evidentiary docket November 26th at 1:30.
Thank you, Your Honor. I will step back and have him sign that. And once he does that, may I be excused?
Yes, thank you, Mr. Schmidt.
Thank you, Judge.
Go.
Okay, well, put me on first.
All right, Mr. Schmidt, who would you like first?
Monty Austin.
All right, this is cause number CR 22-166, State of Texas versus Monty Travis Austin. Motion to revoke, I believe. Go ahead, Mr. Schmidt.
Correct, Judge. We've met with the court. We requested a reset on Mr. Austin.
How long do you think you need, Mr. Schmidt?
I deferred to the DA's office. I would think at least 30 days, but hopefully it'll be done quicker than that, but it's hard to say.
Your Honor, if we could get 30 days, and then if we're able to get a resolution prior to that, we could maybe request a setting prior to that, but I think a 30-day setting would probably get us there.
All right. The court will set Mr. Austin on the next evidentiary docket, which will be November 26th at 1:30.
Mr. Fincher, Nicholas Fincher.
Nicholas Christopher Fincher, CR 20-118. Motion to revoke. Go ahead, Mr. Schmidt.
We have an agreement with the state. We need to set Mr. Fincher for a plea. Would have had it done earlier, but he's been out working it. Had trouble catching him. I finally caught him. So if we could set him for a plea, that'd be great.
Our next available will be November 12th on a Tuesday.
That'll work fine.
All right, court sets Mr. Fincher for plea November 12th at 1:30.
Thank you, Your Honor.
You're welcome, sir.
Jordan Manning.
Jordan Andrew Manning, CR 24-215, CR 24-247. Show that we are set for possible plea in both cases.
Yeah, that's correct, Judge. We have a plea in CR 24-247, which is a plea to an information. And the state's going to take into consideration the indicted offense.
See here. All right, I don't have any plea paperwork for Mr. Manning, so can you tell me what the terms of the agreement are?
I can, Judge. We're pleading to an information deferred on an ag assault deadly weapon. F2. Our agreement is that a finding of guilt be deferred, punishment be assessed at 4 years community supervision, $1,000 fine, ISP, and a no contact order as a condition of community supervision. The state's agreed to reject or dismiss under 1245 unfiled charges. If you'd like for me to read those, I can. Otherwise, CR 24215 is a filed charge that they're agreeing to take into consideration.
Okay, so that's the indicted cause. Are there other unfiled causes? What are those?
They're gonna be DA 2024-924, DA 2023-723, DA 2023-724. I believe that's gonna take care of it.
Yeah, and what are the nature of those three cases?
You got a resisting, a criminal mischief, and a possession. Penalty group 2.
And you said 24 was, did you say a resisting arrest misdemeanor?
2024-924 is possession. Penalty group 2. 2023-723 is resisting arrest. 2023-724 is a misdemeanor criminal mischief. That should be everything.
All right, court cost 290.
Court costs 290, 515 reimbursement, 1,000.
1,000. Any disposition agreement weapon?
Judge, I believe it was a pocket knife. If it was seized, the disposition agreement is contained within the admonishments. I don't know that it was seized. I believe it was seized with a pocket knife, and ultimately he assigned away his rights. I don't see it on the judgment. Let me check.
Yeah, we'll need to have that on the judgment, unless law enforcement then has to file motions after the fact to dispose of any weapons that are seized.
Yeah, and I'm not 100% certain. I'm sure it was, but it's not on the judgment. So we would agree to a non-proton to include the forfeiture of the pocket knife.
Well, rather than do a nut proton, can we get a new judgment, just a second page with a finding that whatever that weapon is, have that sent over?
I have no problem with that, but I just don't know how long that'll take.
Now, I understand. We're going to go ahead and go forward with the plea. I just won't sign that judgment until we get that.
Yes, sir.
All right, Mr. Manning, sir, raise your right hand. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth, so help you God?
So help me God.
All right, you can lower your hand. Your name is Jordan Andrew Manning, is that correct?
Yes, sir.
And Mr. Manning, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
You're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt as your attorney?
Very pleased.
Do you have any questions about the paperwork or anything else about your case before we go forward?
No, sir.
Mr. Schmidt, do you believe that Mr. Manning is competent? And have you explained to him his rights regarding the case and also the advantages and disadvantages of a deferred adjudication plea?
Yes, sir. On all three questions.
All right, Mr. Manning, you are charged and you said it's by information, correct, Mr. Schmidt?
That is correct, Judge.
Is that correct? I'm sorry.
Yes, sir. It is by information.
Okay, so Mr. Manning, you understand that you have not been indicted by the grand jury on this matter. Do you understand that?
Yes, sir.
Yeah, I'm certain that you and Mr. Schmidt have had conversations about what your rights are to have your case presented to a grand jury, and that how you could waive those rights and allow the state to prosecute you by filing an information. Is that correct?
Yes, sir.
And Mr. Manning, understanding that you have the right to a grand jury indictment in your matter, are you telling me today that you are waiving that right intentionally, knowingly, and voluntarily?
Yes, sir.
And you understand that once you waive that right, it cannot be restored to you after the fact, meaning you can't decide in a year or two, or if you violate your probation, you can't come back and say, oh, hey, now I want a grand jury.
Yes, sir.
All right. Court will find that Mr. Manning has been admonished regarding the right to have his case presented to the grand jury, that he has waived the same intentionally, knowingly, and voluntarily, and he has the assistance of counsel in reaching that decision. You are charged by information with the second-degree felony offense of aggravated assault with a deadly weapon that does carry a potential range of punishment of not less than 2 years in prison up to a maximum 20 years in prison and a possible fine not to exceed $10,000. I see that based on your plea agreement, you are asking the court to consider the evidence, defer a finding of guilt, and place you on community supervision for a period of 4 years, along with fine, court costs, and reimbursement fees. Is that your understanding of the plea agreement, Mr. Manning?
Yes, sir.
And also, part and parcel of that is that you will have your other filed case, which is a assault of a peace officer, and resisting arrest, criminal mischief, and possession of controlled substance. All of those cases would be dismissed, and they would be taken into consideration with this plea in this case.
Yes, sir.
All right, understanding all of that, then, Mr. Manning, how do you plead to aggravated assault with a deadly weapon?
Guilty.
And are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Mr. Manning, has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court will accept the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the stipulation of evidence?
No objection. Do you
All right,
need to do that, Judge?
No, I have it here.
Okay.
That's the only thing I have. The stipulation of evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, just due to the kind of the nature that this plea arose was rather quick. So as far as victim contact and support, victim impact statement was not sent out. However, Ms. Cheney was able to get a hold of victim yesterday. Victim was hesitant at first at this plea. However, after conversation, she was supportive of the resolution of the case.
All right, and what about the victim in the assault of a peace officer? Was that victim consulted with their case being 1245?
Yes, Your Honor, and supportive.
And supportive? Okay, thank you. Anything further from the defense?
No, Judge, just that I would point out that in the pled case, there is a no contact order as a condition, so we're well covered on that. But other than that, we rest.
All right. All right, the court's going to review the evidence at this time.
This page is fine on the second page there.
I'm somewhat concerned that the stipulation of evidence does not outline the legal elements required to prove aggravated assault with a deadly weapon. I see it says that he got into an altercation with one individual and then another individual intervened to get him to leave. And then he said he pulled out a knife while she was next to him. I need to know, was the knife brandished as part of a threat? It just says altercation. It doesn't say that there was a threat. I don't think the stipulation of evidence outlines the legal elements for aggravated assault with a deadly weapon.
If defense has no objection to amending it, witnesses to this incident did say that the knife was pulled out in a threatening manner.
Mr. Schmidt, any response?
We would not object to that. I think that would satisfy the elements, and we believe that's probably the case anyways. So.
Okay, so that we're clear, the stipulation of evidence, the last sentence will say, when she intervened, I pulled out a knife I had on me while she was right next to me in a threatening manner.
Yes, sir.
Okay, all right, if you'll make that modification to the stipulation of evidence, then I would find that is sufficient evidence to prove the court will follow the plea agreement and the recommendation of the DA's office. The court defers a finding of guilt, places Mr. Manning on 4 years deferred community supervision, orders him to pay a $1,000 fine, $290 court cost, $515 in reimbursement fees. Court finds that no restitution was alleged or proven. Court orders Mr. Manning, as part of his community supervision, be placed on the intensive supervision program, that he is to have no contact with either Brian Thrower or Michelle Nicole Thorne. The alleged victims in this matter. Further, the court will take into consideration and dismiss under section 1245 cause numbers DA 2024, DA 2023, DA 2024-924, DA 2023-723, DA 2023-724. Those being what appears to be a possession of controlled substance, resisting arrest, and criminal mischief. All right, Mr. Manning, you are hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. Step over to be fingerprinted on your judgment, and then the probation officers will tell you about what's next.
Judge, we do have the correct second page of the judgment here already, so we're good on that.
Great, thank you. I appreciate the DA's office getting that done.
There we go.
Who would you like next?
This is Miguel Marquez.
He completed his affidavit while we've been out here this afternoon, Your Honor, and he meets the eligibility, so I've appointed Mr. Richard Schmidt.
All right, thank you, Ms. Abraham. This is cause number CR 18-366, State of Texas versus Miguel Hernandez Marquez on motion to adjudicate. The court has found Mr. Hernandez Marquez to be indigent for purposes of the Sixth Amendment, appoints the Honorable Richard Schmidt as counsel. Court will reset this motion to adjudicate today to give counsel time to review the case. We'll set this on the court's contested docket just as the next motion to adjudicate or revoke hearing on November 26th at 1:30. And Mr. Schmidt, if y'all work out something prior to that date, then you can obviously let us know and we can get you worked in sooner.
And I think we can, Judge, already.
Ms. Abraham? Ms. Abraham,
Your Honor,
are we expecting somebody from Johnson County?
yes, that is Jose Rodriguez, and then Mr. McBride should be on Zoom also, the
Okay.
attorney.
Johnson, okay, there it is. I see it now. All right, they're here. I'm not gonna bring them in yet, but I just letting you know, I see Johnson County. I don't see I see Alan Steele. I don't know if that's Mr. McBride or not, but.
Could be.
could be.
And then we should have Mr. Bill Stevens.
Yes, I see Mr. Stevens. He's there.
Okay, are you ready? And Mr. Manning is ready on his.
Are you ready, Mr. Manning?
Judge, ready on two, Mr. Hare.
All right,
Here.
go ahead, bring Mr. Hare up. This is cause number CR 23-154, State versus Charles Ray Hare. For motion to revoke. Go ahead, Mr. Manning.
Yes, Judge, this is our first sitting on the motion to revoke. I was just recently appointed on his case. I would ask for additional time for us to negotiate with the state.
All right, court will reset Mr. Hare for the next evidentiary hearing docket, November 26, 2024 at 1:30.
Next, Judge, ready on Mr. James Della. Judge Della James.
Cause number CR 24-236, State versus Della James. Is this going to be a plea today, Mr. Manning?
Yes, Judge.
Court
And
also calls CR 24-237.
Judge, before we begin, just noticed on the judgment, there were a couple of typos. The date for the proceeding was listed as October 29th. As well as in the terms of the plea bargain, it says 5 years community supervision. The agreement was 4 years, and you'll see that reflected 2 lines down. the period of deferred adjudication supervision is 4 years. That was our agreement.
And Your Honor, we'll get a corrected judgment page out there.
All right, so yeah, we need the date to be October 31st and the terms of plea bargain corrected to 4 years community supervision. All right, anything further, Mr. Manning?
No, Judge, I believe that's all.
All right, Mr. James, sir, if you will raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All
Yes,
right, thank you, sir. You can lower your hand. Thank you. Your name is Della James, is that correct?
Yes, sir.
And Mr. James, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work he's done?
Yes, sir.
Do you understand all of the paperwork, everything that you've read and signed?
Yes, sir.
Do you have any questions before we go further?
No, sir.
Mr. Manning, do you believe Mr. James to be competent? And if so, have you explained to him his rights regarding this case and also the advantages and disadvantages of a deferred adjudication plea?
Yes, Judge, I have explained the advantages and disadvantages of deferred. I also explained to him his rights and the waiver of those rights, and I believe he's entering into this intentionally, knowingly, and voluntarily.
All right, you do believe him to be competent?
Yes, Judge.
All right, Mr. James, you are charged by indictment with a third-degree felony offense of evading arrest or detention with a vehicle. That being a third-degree felony does carry a range of punishment of not less than 2 years or more than 10 years in prison and a possible fine not to exceed $10,000. I see the plea agreement in your case is for the court to consider the evidence, not to convict you, but to place you on deferred community supervision for a period of 4 years with a $1,000 fine plus court cost, reimbursement fees, and the state is asking the court to dismiss your unauthorized use of a vehicle case due to your plea in this matter. Is that your understanding of the plea agreement?
Yes, sir.
All right, understanding all of that then, Mr. James, how do you plead to evading arrest or detention with a vehicle?
Guilty.
Now, are you pleading guilty to that crime because you are in fact guilty of committing that crime? Are you pleading guilty because you are guilty? You're not telling me you're guilty just so you can get a probation plea.
I'm guilty.
Okay. And Mr. James, has anybody threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, very well. Court does accept Mr. James's plea of guilt. Mr. Manning, any objection to the stipulation of evidence?
No objection as offered.
That is admitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Nothing from defense, Judge, and we have got a corrected copy of the first page of the judgment.
Excellent, great. All right, court's going to review the evidence at this time. All right, court has reviewed the evidence and does find enough evidence to convict the defendant. Court will follow the plea agreement and the recommendation from DA's office. The court defers a finding of guilt on the third-degree felony offense of evading arrest or detention with a vehicle. Court places Mr. James on 4 years community supervision, orders him to pay a $1,000 fine, $290 court costs, and $520 in reimbursement fees. Further, the court does dismiss under section 1245 of the Texas Penal Code, cause number CR 24-237, unauthorized use of a vehicle. Mr. James, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted on your judgment, and then the probation officers will give you the next steps. Who's next?
Judge, next ready on Ms. Crystal Mosby.
Clause number CR 19-107, State versus Crystal Cosby. And Mr. Manning, I've got a document here that seems to say that the state's recommending that their motion to adjudicate that they filed be withdrawn, that Ms. Cosby be extended on her original community supervision for an additional 1 year, and that her conditions be amended to include new attorney fees due to the violations and the motion filed by the state. Is that correct?
That is correct, Judge.
All right, so tell me, what are we doing to punish her for her violations? Anything?
Judge, my understanding is, at this point, she has been in jail. She's lost some of what she established out on the free world. Our hope is that we get her back on, get her caught up on probation fees, finish up her community service, and be able to get her completed on this rather lengthy probation that she was on.
And why is the prognosis for her being successful now different than when I originally put her on probation?
Judge, she is in a stable living environment. She went through. Judge, she's been in jail for 6 months. She is now going out with a support system. I think it's going to allow her to finish this probation successfully.
Okay, and has count 1 been resolved over in Henderson County?
Yes, Judge.
And count 2 has been resolved in Henderson County?
Yes.
And what was the disposition of 1 and 2?
She received. Judge, she resolved both those through a plea.
Okay. All right, Mr. Cosby, you understand that if I grant this request that you're asking for, that the DA's office is recommending, that any future violations that end up here with a motion to adjudicate upon that being proven to the court, you understand that you're really looking at 20 years in prison?
Yes, sir.
All right. I'm not gonna lecture you now because I think you're old enough to understand and know better. And so I'm gonna go ahead and I'm gonna grant the state's motion to withdraw. I'm going to amend your community supervisions conditions for you to be extended for 1 year. And I'm gonna order you to pay the new attorney fees that were associated with them having to file this motion of $500. And I suggest that you not end up on the docket again.
Oh, yes, sir.
All right, your excuse.
Judge, next we're ready on Miss Haley Saunders.
Haley Delane or Delaney, I don't know, is it Delane or Delaney? Delaney? Delane.
Yes, sir.
Haley Delane Saunders, cause number CR 23-40, motion to adjudicate, I believe. Go ahead, Mr. Meany.
Yes, Judge. Miss Saunders just recently got out of SafeP, and she was in the process of transferring. She had completed the aftercare program, was reporting in a different county. I was in the process of transferring back here. She picked up 2 new charges, and those charges they're still getting the paperwork done for us to resolve those. But Ms. Saunders is going to request to be put back on probation with ISP as a condition of probation, with the anticipation of us resolving those future cases with restitution on the criminal mischief case. Judge, I don't remember if you recall when we originally put Ms. Saunders back on probation earlier this year. We explained to the court kind of the path that's led to her being in this situation. I think the indication that she was able to successfully complete SafeP and all its accompanying time afterwards in the aftercare program is indication that she is on the right path. I think she just needs a little correction to take what happened with this new situation, take responsibility for that, and finish out her probation as I think she can. As I said, they are amending and including ISP as a condition of that probation.
And is the probation department supportive?
Yes, sir.
And so is she pleading true to the violations?
Judge, my understanding this morning was that we were going to plead true and adjudicate, but I have in front of me paperwork for withdraw and continue. I obviously don't oppose that, but and transparency, that wasn't what we had discussed this morning.
Mr. Harwell?
Yes, Your Honor, since they are new charges, rather than having, Ms. Saunders basically waive her rights to, hearings and trials in those new issues by pleading true. And since we were discussing probation anyway, state's position is that, deferred probation or straight probation, either way is gonna be community supervision. The supervision itself does not change, only the adjudication factor. With this, arrangement, Your Honor, believe it allows Ms. Saunders to maintain her rights in the new cases, as well as, I mean, the understanding that this is the last opportunity that she will have, while also allowing the state the full range of punishment if there is any further violations.
So what you're telling me is you're asking to withdraw and amend for ISP, or are you asking me to plead or true adjudicate ISP?
To withdraw and amend to ISP, Your Honor.
Okay. All right, and Ms. Saunders, raise your right hand. I'll place you under oath. You swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God.
Sure.
All right, you can lower again. All right, and so Ms. Saunders, are you amenable to having your community supervision amended to include placement on the intensive supervision program?
Yes, sir.
And you understand that court is not interested in any more agreements between you and the state should you come back?
Yes, sir.
The only thing I'd be interested in is a hearing as to whether or not they can bear their burden. And if they can bear their burden, then it'll be a revocation. And then I'll consider what kind of sentence is appropriate for your original crime. It's not about your violations, it's about what your original crime is, which is aggravated assault with a deadly weapon.
Yes, sir.
You understand that?
Yes, sir.
I mean, do you really understand it?
Yes, sir.
All right, then the court will grant the state's motion to withdraw, the motion to adjudicate. Court will amend, approve the agreement to amend the conditions of community supervision to place Ms. Saunders in the ISP program. And so is the state rejecting other cases? I heard Mr. Manning say something about restitution.
Judge, no, we're gonna still wait for those cases to be brought in, and I've told the state for my clients that she is willing to pay restitution and handle those cases if the state ends up filing a case on those, and we'll resolve those if they do come into fruition. We are going to be submitting an order for bond on those so that she can get back out on probation and continue working, doing what she needs to out in the free world.
Are those felony cases or misdemeanor cases?
Judge, I
Your
believe-
Honor, sorry, Ms. Manning. So one is a state jail and one is a misdemeanor. So both of those would be handled in the county court at law, Your Honor, presumptively. One of the issues and one of the reasons why we came to this agreement is we still do not have the full cases submitted to us. So we haven't had a chance to look into any kind of details, what the allegations are.
Okay. All right, so y'all will be taking up that matter with Judge Winters.
Yes, Judge.
Yes, sir.
Okay. All right, Ms. McCosby. I've told you everything I need to tell you. Go ahead, Mr. I'm sorry.
Judge, this is, yeah, Ms.
Yeah,
Saunders.
I'm sorry. I looked at the wrong one on the docket. So I've told you, Ms. Saunders, everything I need to tell you, okay? The rest of the ball's in your court now. You get to decide if you're gonna stay in bounds or if you're gonna go out of bounds. Okay? All right, your excuse. Who's next, Mr. Manning?
Judge, last, I have Ms. King.
Cynthia King, cause number CR 24-212 or arraignment. Go ahead.
Judge, if we may, I can't remember right now if I've shown Ms. King a copy of her indictment, if we could have that pulled up.
Wasn't indicted yet when we talked.
Okay, I didn't think so. discovered in this case. Judge, Ms. King's name is spelled correctly. She understands the charge against her as well as the range of punishment. At this time, she requests to be set, at this time, she pleads not guilty and requests to be set on the pretrial docket.
All right, court finds that waive the formal requirements of arraignment. The court enters her plea of not guilty into the record, and the court sets this matter for pretrial hearing on December. Are you fine with December 5th, Mr. Manning?
Judge, actually, if we can take that earlier date on the 20th, I think we'll be able to resolve Ms. King's case.
I don't have a 20th. in
I'm sorry.
November. I've got a 14th, November 14th. That's a Thursday. That's my next Thursday docket.
Judge, we'll take that.
I've got the 26th. Is that the one you were thinking of? That's my next evidentiary docket. That's a Tuesday.
Judge, I think we'll probably be able to get something resolved if we can set it on the 14th.
All right, court sets Ms. King then for pretrial on November 14th at 1:30.
Judge, I believe that concludes on business. May I be excused?
Yes, thank you, Mr. Manning.
Thank you.
I'm going to go ahead and bring in Johnson County Detention Center and also Mr. McBride or Mr. Steele. We'll see who it is.
It's Alan Steele, Your Honor.
Are you here for Mr. McBride today?
I am.
All right, thank you. That's what I thought, but I didn't want to make that assumption. I've done that too many times and it's not worked out for me. So,
I understand. I appreciate it.
yeah, absolutely. I've got Johnson County coming in right now. We're going to give them a second, see if they can get going. If anyone in the Johnson County Detention Center can hear me, that we're ready for the hearing on Mr. Josue Rodriguez. They logged in early.
Okay. There you go.
All right, thank you. I appreciate
Can you
you.
hear us, Judge?
Yes, we can hear
All
you.
right, thank you.
Can you see and hear me as well?
And yes, sir.
Okay, can you see your attorney, Mr.
No, I
Still?
cannot.
Okay, so you may have to change the view to gallery view.
The mouse. I can't see my attorney.
Go to your upper right-hand
Yeah,
corner.
they
Hold
took
on a second, sir.
the mouse.
Yeah, it's okay. I'll give you a second. What you'll do is you'll go to the upper right in the view and make sure that you click gallery view. And you'll be able to see the prosecutor, the court, and your attorney, Mr. Steele, today.
So be. Gallery.
Which one is yours? Which one is yours? That's all of the party. That's everyone. Let's see. We make it there. Who's your attorney?
Mr. Steele.
Yeah, we can see Alan Steele. He's on here.
Mr. Steele is standing in for Mr. McBride today. If you're expecting to see Mr. McBride, Mr. Steele is standing in because he's unavailable. All right. Well, thank you. All right. So court calls number CR 18-503, State of Texas versus Josue Rodriguez. This is a hearing on his motion to revoke. Mr. Steele, I find that you're standing in for Mr. McBride today. Any announcements?
Judge, I believe Mr. McBride has been in conversations with the district attorney on this case. There is a Johnson County case that is my understanding is still not indicted. We're trying to figure out what's going on with that. I will be handling that case in Johnson County, so I'm trying to get the DA to call me back and tell me what the situation is, honestly. But it's my belief that I think we can work something out on this at some point. I just need to find out about that case before we move forward, and Mr. McBride's aware of that and working to that end as well.
And Your Honor, I can speak to that. I've been speaking with Mr. McBride. We have been working on figuring out a resolution to this. I believe we're close. So I think we may very well be able to get this done at the next setting. Of course, you know, what pending whatever conversations Mr. McBride needs to have with Mr. Rodriguez, but I do believe we are close.
All right, then what the court can do is set this for November 26th. That's my next evidentiary docket. It's approximately 30 days, a little less, and that'll give you all time to try to figure out what you're going to do with Johnson County, how it's going to affect this case. Okay.
Okay, Judge.
All right, so I'm going to set it for November 26th at 1:30, and that'll be here at the Van Zandt County Courthouse.
Okay, I will confirm Mr. McBride's aware of that, Judge, and I'll work on the Johnson County stuff on my end to see if I can move this along.
All right, thank you, Mr. Steele. I appreciate you standing in today. And Mr. Rodriguez, I can't send you a notice, but your attorney has it, and so your bondsman will be aware of it also. So tell the Johnson County staff I appreciate their help in allowing me to zoom in today.
Am I still on bond in Van Zandt County?
I don't know. It says, it just shows your bondsman here on my docket, so I don't know.
Okay.
It's a good question. I'll look that up, and I'll have Mr. McBride notified if you still are.
Okay, thank you.
All right, you're welcome. All
Thank
right,
you.
nothing further than we're adjourned in this hearing.
Thank you.
Thank you.
You bet.
Have a good day.
You as well.
Your Honor, Mr. Lowe is ready on the plea on Mr. Lyons.
All right, come on up.
Afternoon, Your Honor.
Good afternoon, Mr. Lowe. How are you, sir?
I'm okay.
All right, this is cause numbers CR 24-248, CR 23-221, and CR 24-249, State of Texas versus Jonathan Lee Lyons. Mr. Lyons, sir, if you'll raise your right hand, I'm going to place you under oath. Here, go ahead and step over those. There we go. If you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, thank you. You can lower your hand. All right, Mr. Lyons, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Doug Lowe. Are you pleased with Mr. Lowe and the work he's done for you as your attorney?
Yes, sir.
Do you have any questions about the paperwork, that your plea agreement that you signed, or about your case?
No, sir.
All right, and Mr. Lowe, do you believe Mr. Lyons to be competent today?
I do.
And have you explained to him his rights regarding this case? And if so, do you believe that he's entering into this agreement intentionally, knowingly, and voluntarily?
Yes, sir, but yes to both questions.
All right, thank you, Mr. Lowe. All right, Mr. Lyons, I'm going to go over some of the information in your case. I'm sure that you and Mr. Lowe have already gone over it, but I'm going to go over it again, okay? In cause number CR 24-248, you're charged by, it says information. Is he charged by information in both these cases, Mr. Lowe?
Yes, we're waiving grand jury and going for information.
Okay. All right. So, Mr. Lyons, you're charged by information with the cause of a state jail felony possession of a controlled substance in penalty group 1, less than 1 gram. That would carry a range of punishment of not less than 6 months in prison, up to a maximum 2 years in prison, and a fine not to exceed $10,000. In cause number CR 24-249, you're also charged by information with harboring a runaway child, which is a class A misdemeanor, which carries a range of punishment of up to a maximum 365 days in the county jail, and a fine not to exceed $4,000. And lastly, your third charge is, actually, I don't even know because it's not on my docket. What is cause number CR 23-221, Mr. Lowe?
Your Honor, the court will recall we had a motion to suppress with the officers from Wills Point, and that is CR 23-00221. That was delivery of controlled substance to a minor. And so that case will be dismissed today in exchange for his plea to the other, these two causes.
Very well. All right. So, Mr. Lyons, do you understand that in cause number CR 24-248, that being a felony level offense, you have the right to have your case presented to the grand jury? As a matter of fact, people in Texas cannot be prosecuted for a felony offense unless the grand jury has reviewed the evidence and made a finding that they believe that it's more likely than not that the person accused has committed the crime. However, because you are the accused, you have the right to waive that grand jury and allow the state to prosecute you on an information rather than taking your case to the grand jury. You do understand that, correct?
Yes, sir.
And you understand that if you waive your right to a grand jury today, you don't get to reassert that right later down the road, meaning you can't change your mind if you don't like what happens later.
Yes, sir.
And Mr. Lyons, you've had Mr. Lowe as your attorney for quite some time now. You've gone all over this paperwork and you understand all your legal rights. Is that correct?
Yes, sir.
And Mr. Lyons, has anybody forced you, pressured you, or otherwise persuaded you that you had to waive your right to a grand jury indictment?
No, sir.
Okay, then the court will find that Mr. Lyons has been admonished as to the right to a grand jury, that he has waived the same intentionally, knowingly, and voluntarily, and he's had the assistance and advice of counsel. All right, Mr. Lyons, I see that the plea agreements in your cases for the possession of controlled substance state jail felony, the recommendation is that upon your plea of guilty, that your punishment be assessed at 2 years in prison with a $2,000 fine, restitution of $180, and the DA's office would be dismissing that unindicted cause, DA 2023979, which is another possession of a controlled substance. And in the harboring a runaway child, the recommendation is that's a class A misdemeanor. Their recommendation is that you be convicted of that offense, that your punishment be 1 year in the county jail, with you receiving credit of that 1 year for the time that you've already served, which is 365 days. And on your felony case, you would receive jail time credit of 421 days for the time that you've already spent in jail. Is that your understanding of the plea agreement and what you want the court to approve?
Yes, sir.
And then, as Mr. Lowe has already referenced, cause number CR 23221, the state has tendered a motion to dismiss, and that case would be dismissed as well. Okay. All right. Understanding all of that, Mr. Lyons, I have to ask you at this time, how do you plead to possession of a controlled substance in penalty group 1 less than 1 gram?
Yes, sir.
How do you plead to harboring a runaway child?
Yes, sir.
And are you pleading guilty to each one of those crimes because you are in fact guilty of committing each one of those crimes?
Yes, sir.
And Mr. Lyons, has anybody threatened you, forced you, pressured you to plead guilty to either crime?
Yes, sir.
Very well. Court does accept the defendant's plea of guilt. Mr. Lowe, any objection to the stipulation of evidence?
No, so stipulated.
All right, the evidence is admitted and the court does take judicial notice of the defendant's judicial confession in each cause. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense, Mr. Lowe?
No, Your Honor.
All right, the court's going to consider the evidence in each case. All right, the court, having reviewed the evidence, finds that there is sufficient evidence to convict Mr. Lyons. Court will follow the plea agreement and the recommendation of the DA's office. In cause number CR 24-248 on the charge of possession of controlled substance in penalty group 1, less than 1 gram, state jail felony, the court convicts Mr. Lyons, assesses his punishment at 2 years confinement in the Texas Department of Criminal Justice State Jail Division, orders him to pay a $2,000 fine, restitution of $180. The court dismisses unfiled possession of controlled substance in penalty group 2, which is DA 2023-979. Court awards Mr. Lyons 421 days credit towards his sentence for the time that he has spent in jail on this cause. In addition, the court does order him to pay a restitution of $180 and reimbursement fees of $15. In cause number CR 24-249, the court, having considered the evidence, hereby convicts Jonathan Lee Lyons, follows the plea agreement today, assesses punishment at 1 year confinement in the county jail on the Class A misdemeanor, gives him 365 days credit towards that time for time already served. Court orders him to pay restitution in the amount of $233, court costs of $270, and reimbursement fees of $665. Lastly, the court dismisses cause number CR 23221. Mr. Lyons, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. In just a moment, you're going to be over to fingerprint with the deputy. And then also, when you are released from TDC, if you've not already paid off your fines, fees, those things, you need to report to the courthouse, go to the clerk's office on the 3rd floor and let them know that you need to make a payment plan. Otherwise, you may get a warrant for failure to pay fees. Okay. All right. Thank you, sir. You can step over to be fingerprinted.
Okay, that's all I have.
Thank you, Mr. Little. Appreciate you, sir.
Yes, sir.
All right, court's going to bring in Mr. Stevens. I don't think, is there anything left? Oh, yeah, so Mr. Young was right there. So is there anyone else left at the jail other than?
No, sir, just Mr. Young.
Okay, all right, Mr. Young, come on up. Let me bring in Mr. Stevens here. Actually, Mr. Stevens is no longer in the waiting room. Just go ahead and have a seat, Mr. Young. And Mr. Abraham, do you want to contact Mr. Stevens? He was there earlier, but he's not now.
Your Honor,
Yes, ma'am.
he did not answer. I sent him a text message. I know he was also going to be in court in Kaufman County.
Okay.
So we'll just wait till you tell us he's on there.
Okay, we'll just stand in recess and I'll sit here and see if he joins back in. All right, court's in recess until Mr. Stevens is available to appear.
Judge, can you hear me?
Yes, sir, I can. Good afternoon.
All right, good. I'm in my truck, so don't know how good the reception's going to be or how good you can see me, but I'm here.
Yeah, I'm good. Do you mind, can you take your sunglasses off for me?
Yes, sir.
All
I'm in
right,
my truck and sun's glary.
I got you. This is cause number CR 21-98, State versus Reginald Young II. Mr.
Yes,
Young
sir.
set for trial, number one, I believe, next week. And Mr. Stevens, you filed a motion for continuance. The court has reviewed the motion, and I understand the state's not in agreement, so I was going to let defense argue the motion. Because that this is a public forum and in that it is also appearing on YouTube, I want counsel to be careful about what information is disclosed so that we don't unnecessarily impugn any potential jury members with knowledge of the case. But
Yes, sir.
I understand the contents of the motion. Go ahead and give me the legal argument as to why you need that, and then I'll let the state lodge their objection, if any.
Okay, Your Honor. As my motion said, I have been unable to get a hold of my client for probably a week. Phone was turned off for him. I couldn't communicate with him to get him in the office to prepare for trial. And then I get a message, I guess Monday or something, that he had been rearrested. So I went to see him yesterday. The first time I'd seen him in quite some time. Then I find out yesterday, Judge, I was dropped off at my office sometime after 4 o'clock, I guess, a thumb drive with like 13 different videos on it that I've just gotten for the very first time. I hadn't even looked at it, Your Honor. And my client he's picked up some new charges. And so I mean, if we try this case, the problem is if he's convicted, his new charges, he's 25 to life on. And so with all that being said, Your Honor, we're asking for a continuance, and I might can even work something out to wrap everything up. I don't know if I can or not, but that's my position. I just can't be ready when I got all this videos and stuff that I got to look at, and I hadn't even seen them yet, Judge. So that's basically, that's my motion.
Okay, state response.
Your Honor, that is correct. When our special set case went away, we started digging into this one. We discovered that kind of the events leading up to this arrest, there were some videos from Smith County Sheriff's Office. Once we discovered that there could be videos, we made requests to get those as soon as possible. We got them, I want to say Friday. And then it took some time to get those downloaded and then get them onto the portal, and as well as get a flash drive over to Mr. Stevens' office. I can tell you after reviewing those videos, just from my review, they really have to do with that Smith County investigation, in which Mr. Young, I don't believe, was ever even a suspect in. More just kind of a ancillary issue. However, I understand that Mr. Stevens needs to be able to review those for his case. I believe, Your Honor, an appropriate disposition on those videos would be to suppress them as far as the state's case goes. Allow Mr. Stevens, if he finds mitigation or exculpatory information, to be able to use, for Mr. Stevens to be able to use them. Suppress them for the state's case. Beyond that, Your Honor, I do understand Mr. Young's new arrests. However, state can't really control if somebody gets arrested while there is a new case pending.
What's the state's position on any new allegations wanting to use those against Mr. Young in trial?
To be completely honest, Your Honor, we're aware of what the allegations are, but we have not yet seen any evidence. So I'm not sure that the state would, as far as its case in chief, Your Honor, I don't believe that the state would be in any position to use that as 404B. As far as if the case reached a punishment phase, at this point, Your Honor, I'm not really sure what any of the facts are.
Okay, Mr. Stevens, if the court were to, as Mr. Hartwell said, to limit the state on their ability to use any of the information that they have provided to you in the form of videos or any new allegations against Mr. Young, would you then be in a position to try the primary charge in which he's indicted for?
Judge, I was still asked from a continuance because I haven't been able to properly prepare because of not communicating with my client. I tried to get him to his mom too, and I just got a hold of his mom today. Apparently their phones were off. So it kind of puts me behind the 8 ball somewhat, Judge. So I'm still asking for my continuance.
I understand, but the court knows that Mr. Young was out on bail, was he not? So he had plenty of opportunity to, I know it's not your fault, Mr. Stevens, but it's Mr. Young's, it's to his disadvantage that he did not communicate with his lawyer to prepare for trial. And he's in the position he's in now. You definitely can meet with him now before Monday and Tuesday of next week. Evidence is not going to start until Tuesday. And so if we need to move, evidence to Tuesday afternoon or something to grant more time, I don't believe it would be appropriate to let Mr. Young lay behind the log here and not speak with his lawyer, than to put himself in a position to have you ask for a continuance because he's failed to go in and meet with his lawyer. So at this point, Mr. Stevens, what the court is leaning to doing is if there's no resolution between Mr. Young and the state by tomorrow at the close of business, then to go ahead and take Mr. Young to trial, deny the continuance request, take him to trial on the prohibited weapon. I would limit the state in their ability to use any of the evidence that would be deemed late disclosure, not because they're late because they're missing deadlines, but because they're just now getting the information. So any of that information would not be used against the defendant at his trial, but would be at the defendant's, it'd be at his availability, should he want to use anything in there. But I don't believe that, from what I've heard from the state, that any of the information that's been disclosed is relevant to the prohibited weapon charge that he was indicted for in CR 2198, that they're all additional, either ancillary matters or they're additional charges that may be coming down the road. So absent a resolution to resolve everything, the court would certainly be willing to entertain that. Or if, Mr. Young wanted to waive his right to a jury trial on this matter, and we could set it for a bench trial down the road, or something, to that effect, I'd be willing to do that. But at this point, Mr. Young's been on the trial docket for quite some time.
Years.
He's reached the top of the trial, and so now I've already summoned the jury, and they'll be here on Monday. And I don't want to lose them unless there's some kind of resolution.
Yes, sir. I understand that.
And Your Honor, I'm sorry to interrupt, just for purposes of clarification, there was one DVD, none of the videos that were provided this week, those 13 Smith County, those are all new. There was one DVD that was provided in 2022, believe, of an interview. So I just want to make sure that the record's clear that one was provided at the outset of the case. It's a Van Zandt interview.
And you're saying it was produced to Mr. Stevens and Mr. Young when?
I have the date of pickup at September 22nd of 2022.
Okay, so that's not one that's been turned over recently.
Right.
But
Yeah.
all the other. Go ahead, Mr. Stevens.
I was just going to ask Chris if you could make another copy of that video for me.
Absolutely.
And I'm going to see my client late in the morning, and I'll just stop by your office and pick it up if that's okay.
Absolutely. We will have another copy for you, sir.
Okay, I do appreciate it. It's not that I don't have the other, just in case I get to my office and can't find it or something,
Completely understand. Yeah. It's been a little while.
Okay, so as I said before, absent an agreement to resolve all of the cases in which the court would entertain, the court would then could cancel the jury for next week. If there is no resolution, and if it even is to resolve this case and not the other cases, the court is amenable to that as well.
Okay, Judge.
But what the court is not amenable to is no resolution on this case. And so the court would the court would deny the defendant's motion for continuance. However, the court would order the state that it is not allowed to bring up in any manner any of the videos that have been disclosed regarding the Smith County cases that Mr. Hartwell for the DA's office has mentioned, or any new allegations that Mr. Young may be under at this time, so that those would not affect Mr. Young in this trial. And
I just want to make sure.
Go ahead.
I just wanted to make sure I understand. So if we get something worked out for the trial pending Monday, but we don't resolve the other issues, is that something we can still present to the court then for a plea?
You're saying that say that again?
If you had said that we could pass the case if we worked all the cases out to plead. My question is, if we don't work out all the cases to plead, but I do have some plea agreement made on the case pending court Monday, is that something I can take care of just that one case? Or would you not accept a plea?
You're talking about the prohibited weapon charge that he's under indictment for?
Yep.
For
Yes, sir. Yes, sir.
If you work out the prohibited weapon and there's a resolution on that, the court is amenable to that. And so
Okay, Judge.
I'm not requiring you to resolve all the cases, because I know that the defense and the state may not be in a position at this time to be able to intelligently discuss and understand, what the state's given up or what the defense has given up. However,
Right.
I do want this one off my docket, and we're either going to do it by an agreement that's approved by the court, or we're going to do it by a global plea with everything, or we're going to do it by an open plea to the jury, or we're going to do it by maybe a waiver of jury trial and setting it for a bench trial at some other time. But and if that's the case, then state, I will work with you on the remainder of the top 10 list.
Yes, sir.
All right, Judge. I appreciate it, sir.
So this is what I need from council. I need to hear back from you no later than 4 p.m. tomorrow, if there is going to be a resolution. And if Mr. Young is going to resolve a case, then I need one of two things. I either need a waiver of jury trial so that I can cancel the panel for Monday, or I need to have it in court and I need to have him pled out tomorrow. So I've got civil cases throughout the day and I can work those out, but I do not want to cancel the panel until I have something in writing from Mr. Young.
Yes, sir. Well, I'm going to see Mr. Young late in the morning, and then I will go by and visit with the district attorney, and we'll get it taken care of.
All right. Thank you, Mr. Stevens. So I'm going to go ahead and deny the motion for continuance. I'll write up an order denying the motion for continuance, and I'll also put in the other parameters that's been outlined by the court.
Okay. Thank you, Your Honor.
You're welcome.
Thank you, sir.
I'll have that email to both defense and state.
All
Yes,
right, sir. Thank you, Judge.
All right. I'll hear from you guys tomorrow.
Have a good. All right. Thank you.
All right. Y'all have a good day.
All right. You too.
All right. Thank you, Judge. I think that does conclude the court's criminal docket for the afternoon. So we are adjourned.